Jay-Z is fighting for his life, trying to get rid of this lawsuit that he has been named in, along with Diddy, being accused of SAing a 13-year-old girl back in 2000. He is trying his best to get this case dismissed, while Diddy is trying his best not to have additional charges added to his criminal cases. We are going to be checking in on Diddy's criminal case coming up probably this Thursday to see what's going on over there. But today we are going to be covering the update of Jay-Z trying to get this case dismissed again. I think this is like the third motion to dismiss that he's filing, but it's the first one that he is actually filing properly. He asked the court permission to file this motion. There were deadlines given, and he is actually complying with those deadlines, although I think he did ask for an extension here. This is also the case against Anthony Busby, the attorney that is just suing a bunch of people, or not suing a bunch of people, suing Diddy with a bunch of his own clients, claiming that he has over 120 cases in which Jay-Z filed a motion for sanctions against Busby, but for claiming that, one, he's not even licensed to practice in the court, and two, he's just doing improper thing by not vetting his clients. Now, since we last talked, Jay-Z has removed that motion for sanctions against Busby, basically claiming that he did things wrong. And Busby has actually submitted documentation, or no, he hasn't submitted documentation. It's in the email, I believe, to the court saying that he is now applying to be not introduced, to be licensed to practice in the court. And the court has now entered an order that Busby must give them the documentation that he is now able to practice in court. And so today we are going to talk about whether Jay-Z has a good chance of getting this case dismissed finally, now that he's following the proper procedure. If y'all are new here, welcome to the Brihive. If you're a returning, welcome back. Nice to have y'all in tonight. As you know, we are going to be checking the chats at the end of the live stream. So if you have thoughts, if you have comments, if you have chats, go ahead and drop them while I go through the documents, and we will get to the end of them at the end of the live stream. And if you're watching it on the replay, we do have timestamps down below. So let's go ahead and jump into it. And if you haven't already, please do hit the like button. It does help us out. And if you're not subscribed, please do subscribe. Let's go ahead and see Bossy B. Uh-oh, I forgot. Here we go. Now we had Bossy B across the stream. So let's just kind of regroup ourselves. Busby sued Diddy, claiming that he SA'd a 13-year-old girl with another celebrity, with a female celebrity in the room watching. What adults do this? Apparently, according to Busby, Diddy and his friends do these kind of things. So they filed the motion, I think, back in August. And then in December, they add Jay-Z and say he's the other male celebrity that SA'd this little girl. And that was 13 years old at the time in 2000. This lady is now an adult. I believe she's like 37 years old or something like that. There has been articles coming out where she is saying, these are the allegations. Okay, well, maybe I messed up there, and maybe I messed up there, and maybe I messed up there. And I have thoughts about this motion to dismiss and the facts that Jay-Z is harping on, and I'm going to say he's harping on it, or his attorneys are harping on these facts that I don't know if they're going to hold a lot of weight. And y'all can let me know if y'all disagree with me or not, but I do feel like he is harping on facts that, yes, while they are relevant, I don't think that is going to be the main basis of getting the case dismissed. So let's just kind of remind ourselves of what's going on. And I actually have the wrong document pulled up, so let's go ahead and have me, oh no, that's the right one, right? Yeah, this one. No, this one is the right one. Okay, here we go. Let's share the screen, Bree. That would be helpful to the people. All right, so let's jump in and remind ourselves of what's kind of going on here and whether we're in agreement with Jay-Z and if this case should be dismissed. And before we really get into stuff, y'all watching live and on the replay, go ahead and drop in the chat section if you're live. What do you think? Do you think that this case needs to be dismissed? Do you think Busby is the one that's in the wrong here? Do you think Jay-Z needs to just let this case play out and wait till Diddy can actually interact in the case before trying to fight this case? It can't go forward because of those criminal cases or those criminal charges pending against Diddy. Could Jay-Z be trying to save his own back by saying, hey, I'm not involved. Please do not file criminal charges against me because of what Diddy got going on? What do y'all think about the case? And I forgot where I was going with my train of thought. So that's all I have for now. Let's remind ourselves of what's going on. This is Jay-Z's motion to dismiss the plaintiff's claim that he R-worded her back in 2000 when she was a 13-year-old girl. They go on to let us know plaintiff here pins her legal claims on a statute that paves a pathway to relief for victims of gender-motivated violence in the hope that she can thereby resurrect a decades-old claim just months before the close of the statute's revival window. But her claims, which are meritless at their core because Mr. Carter did not commit the heinous acts alleged, are I knew I was going to be able to say this right, are insusceptible to the statutory resurrection that she attempts and remain outdated as a matter of law. At the time plaintiff asserts she was S8, the statute she relies on did not exist. It was not on the books. And even if it could cover the conduct plaintiff complains of, it is preempted by 2 New York state laws, which specify revival periods that have already expired. Finally, the First Amendment complaint does not and cannot allege that the conduct occurred within New York City, so as to fall under the cited statute. So let me just go ahead and acknowledge the things that I'm having a problem with that he's focusing on just in this first paragraph. I agree that there are some statute of limitations that she's trying to bypass by going under the gender motivated violence act, while there was also the Child Survivors Act that she could have sued under, but she waited until the last minute. So she's trying to sue under a statute that has a revival period that is still open. I do agree with him on that. I don't agree with him that he keeps trying to focus on the fact that it did not happen in New York City. I believe that the statute said it has to be in New York State or New York City, and they actually cite case law throughout this document saying either or. Some of the cases that he cites says New York City, some say New York State, some say New York City and state. And so he kind of harps on that fact. And then he also harps on the fact that this happened 3 months before the statute, or it allegedly happened 3 months before this statute actually went into place. She's claiming that something for the Gender Motivated Violence Act came into place December 2000. She's alleging that the incident happened September 2000, but there has already been articles that have come out that she says maybe it was 2003, which will then make her claim valid again. So he's asking that she not be able to amend her complaint, because if she amends it, it's going to be wrong. We'll talk about a little bit more about getting those dates wrong as we go through the case, but I don't know if these are the strongest allegations to say, okay, well, this shouldn't go forward because of these statutes and it didn't exist at that time. So let's go ahead and jump more into it, and we'll talk about it more as we go through. So the First Amendment complaint asserts that nearly a quarter of a century ago, on September 7, 2000, plaintiff traveled from her home to New York City to attend the Video Music Awards at Radio City Music Hall. After speaking with multiple limousine drivers, she claims to have talked her way into an invitation and a ride to a party hosted by Mr. Combs at the celebrity-filled party purportedly held at a large white residence with a gated U-shaped driveway located within 20 minutes of Radio City. Plaintiff asserts that she was R-worded by 2 male celebrities while an unnamed female celebrity watched. She contends that Mr. Carter was one of those men. But plaintiff's astounding allegations found more than 2 decades after the alleged incident are untimely and therefore cannot proceed. That is no mere technicality. Time bars exist to avoid the errors and injustices that can result from litigating claims that have been allowed to slumber until evidence has been lost, memories have faded, and witnesses has disappeared. And remember, she said even the person that drove her to the VMAs is no longer alive. So we can't ask that person. Her dad says, no, that never happened. And she doesn't have any other witnesses, right? She has an anonymous limo driver that apparently invited her to the party. She has a person that is unalive, that is not alive, who can't testify to the fact that they actually drove her to the VMAs. And her dad, who allegedly picked her up from the VMAs, says that, no, he didn't do that. He did not drive his daughter 6 hours to come save her from some trouble she done got herself into, right? They protect defendants. Sorry, let me go on. I'm in the wrong paragraph. Okay. But plaintiffs, no, I already did that one. The witnesses have disappeared. They protect defendants like Mr. Carter, talking about the statute, The statute protects defendants like Mr. Carter's from having to defend hard-won reputation in the face of uncorroborated allegations. This case has already exemplified the legislative purpose behind the statute of limitations, as plaintiff has publicly admitted that many of her allegations were false, that she made some mistakes, and that she guessed about key details in her story, including how long the drive took to get to the party. And she has identified no witnesses who can substantiate her claims. All told, the majority of plaintiff's allegations, including that she watched the VMAs on a jumbotron, that she spoke to a limousine drivers outside of Radio City, and that she spoke with certain celebrities at the party, and that her father drove her home, have already been exposed as false or inconsistent. The thing about them saying that her statements have been false or inconsistent is that they're not on pleadings. The only pleadings that she has filed of her recollection of the events have been the complaint and then the first amended complaint. He is referring to an interview that she did publicly that is not in the court record. So I think that's going to be really interesting. Of course, I assume he's going to try to get those transcripts admitted when they have the actual hearing for the motion to dismiss. But other than that, he's referring to things that are outside of the first amendment complaint, and the court cannot look at it other than things that they take judicial notice of, meaning like things that you can't dispute. You look up what was the weather on this day at this time, whatever. We should have record of that. The court can take judicial notice of that kind of stuff. Or we filed a lawsuit in California. They can take judicial notice of that case because it is public record. But her interview is considered hearsay, quite frankly, especially if you're citing the article, because that's someone else writing down what they heard from her. We're talking about hearsay. That's not going to be the best evidence. So I wanted to kind of make a comment on that. And then it goes on to say, indeed, she claimed, and the plaintiff claimed with certainty, that one of the celebrities she spoke to was binging Madden, but that conversation never happened. And again, she never said it never happened. She just said, oh, maybe I was mistaken, right? And again, we're talking about documents that are outside of the court's record. So it's going to make it hard for, I mean, I guess he'll be able to try to introduce the evidence, but it's really not before the court yet. Jay-Z is just putting it before the court by keep bringing it up in all of his documents, honestly. Plaintiff claims that she may proceed with the action because her Stell claim was revived by New York's Victim of Gender Motivated Violence Protection Act that is legally erroneous, and for two simple reasons. First, plaintiff impermissibly seeks to apply the Gender Motivated Victims Protection Act retroactively. Remember, plaintiff is claiming that the incident happened September 2000 and the act went into effect in December 2000. So he's basically saying she can't use it to apply it 3 months prior to when the statute was enacted. The first amended complaint alleges that plaintiff was assaulted in September 2000, but the GMVPA was not enacted until 3 months later in December 2000. Because the GMVPA did not exist as of September 2000, it does not provide a cause of action for the alleged events at the time, nor does the statute's plain text or even the legislative history for that matter. State only even suggests that it should be applied retroactively to annotated conduct. Notably, every court that has considered this question in this context has declined to extend the statute to the conduct that predated its passage. Applying the statute in ways never suggested by the legislature would not only raise grave unconstitutional concerns, but would violate due process and ex post facto clauses of the U.S. Constitution. And essentially, those are just mumbo jumbo words of saying, I have to know what laws are in place. Although we don't know all laws, right? No one, maybe some people, but I can probably guarantee you that no one knows every single law in their state, in their county, right? Although we are expected to. Like, an excuse for committing a crime is that you can't say, it's not an excuse to say, oh, I didn't know that was a law. That's not an excuse. So what they're arguing is that that was not even a law at the time. So I couldn't have even known that I was doing something, even if I am guilty of it. So the law needs to be in place at the time in order for me to be guilty. In order for me to know that I am potentially liable, the law needs to be enacted at the time. And they're saying it was enacted 3 months later, which, I mean, it's a rule. It's a rule, right? Second, even if the GMVPA could apply retroactively, it cannot. Plaintiff's claim is preempted by New York State Child Victims Act and Adult Survivors Act, consistent with Judge Kaplan's recent decision addressing the same issue. The CVA and the ASA collectively create a comprehensive legislature scheme that encompasses the entire field of civil claims for SA, reflecting that state legislature intent to take full responsibility for regulating this area. And the GMVPA revival period directly conflicts with that of the CVA and the ASA, which resuscitates cell claims only until August 2021 and March 2023, respectively. That reflects the considered judgment that the state legislature balancing the critical interest in protecting defendants from the potential injustice of litigating stale claims and providing compensation for true victims of SA and of SA and New York City cannot depart from the careful legislative choice under principles of conflict preemption, because plaintiff's claim would not only be timely under CVA, is barred now. So what is all that mumbo jumbo that they're talking about? They all have different revival periods, right? So we'll get into it a little bit more, but the CSA for the child survivor, she was a child at the time, so they're applying that one to her. She's a Child Survivor Act that was revived even if the claim had been stale, even if they were outside of the statute of limitations. They revived that from, I think, like 2019 to 2021. For the Adult Survivors Act, they revived that from something 2021 to 2023. Or no, wait, maybe it was 2022 to 2023. And then this gender motivated is now revived until March of 2025. So the only one that was open for her to try to get some kind of relief under was the gender motivated act, because the Child Victims Act, Child Victim and the Adult Survivors, those ones, the statute or the revival period has already ended. And they're basically saying she can't use the gender motivated because that law was not enacted at the time that they are claiming that the incident happened. I hope that makes sense. I feel like I'm just rambling. I hope that makes sense. Anyways, let's go on. Third, regardless of the claim's viability and timeliness, plaintiff has failed to state a valid claim for relief because the First Amendment complaint does not allege that the unlawful conduct that purported SA occurred within New York City territorial boundaries, nor could it. Plaintiff asserts that after leaving Radio City within 20 minutes, she arrived at the party hosted by Mr. Combs in a large white residence with a gated U-shaped driveway. But Mr. Combs did not own a residence that fit that description in 2000, and publicly available information demonstrates that there is no residence meeting that description within 20 minutes of Radio City that is located both in New York City and within the boundaries of the Southern District of New York. For each of these reasons, plaintiff's claim is due to be dismissed, and because amendment cannot cure the fundamental flaws concerning the retroactivity and preemption, dismissal should be with prejudice. So what she's probably going to argue on a lot of it is that she needs to do discovery to find information to make sure that she's given us the right dates. The other thing that they seem to harp on is the house and the U-shaped driveway and the gates. We're talking about something that happened 24 years ago. Could they have changed the plans and what the aerial view will look at? I don't think you could go back in time and look at what the property. They did attach some exhibits, right? That we can look at, or we're not looking at it today, but they did attach some exhibits where they're purporting to these are the houses at this time. But if you're just doing a search now, like how they talk about, in traffic, you can only make it this far and that far. In 2000, was the traffic the same as in 2024 and 2025, right? If you're using Google Maps, because they do use Google Maps to calculate these things. I know with Google Maps, you can kind of time, okay, well, if I leave at 7 o'clock, how long is it going to take me to get here? But you can't go, if I left at 7 o'clock from September of 2000, how long would it have taken me to get there? That's going to be a hard argument to make, but either way it goes, let's go ahead and jump more into the background. This is kind of just repeating and letting us know what her allegations are and what they have a problem with. So I am going to read that one because they kind of point out, okay, these are the homes that he owned and all of the things. So factual background, plaintiff alleges that on September 7, 2000, when she was 13 years old, a friend drove her to Radio City to attend the VMAs. She claims she remained outside and watched the event on a Jumbotron. During the VMAs, she purportedly spoke with numerous limousine drivers until she stumbled upon one who told her she fit what Diddy was looking for. When the VMAs ended, she claims that this person drove her approximately 20 minutes to a party hosted by Mr. Combs at a large white residence with a gated U-shaped driveway. At the party, she claims to have recognized and spoken with many celebrities. Shortly thereafter, plaintiff contends that she was drugged and SA'd by Mr. Combs. She asserts that Mr. Carter, previously unnamed in the complaint, also allegedly assaulted her. Following this alleged encounter, plaintiff reportedly fled the house and continued running until she reached a gas station. There she claims she spoke with a female clerk and called her father and asked him to pick her up. Plaintiff's father purportedly picked her up shortly after dawn. Not only have many of these factual allegations been shown to be demonstrably false, but they cannot prop up a sole claim that is legally deficient. The First Amendment complaint asserts a single cause of action, a violation of the Gender Motivated Victims Protection Act, because plaintiff was allegedly forced to engage in sexual interaction without consent. Although the First Amendment complaint asserts in a conclusory fashion that a substantial part of the events or admission given rise to the claims occurred in this district, which includes New York and Bronx County, as well as several outside of New York City, it does not specify the location of the residence in question. It does not list the residence's address, identify whether it was located in New York City, and if so, what borough, or even if it was located in New York State, and if so, what county. Public property records, however, show that Mr. Combs, the host of the purported party, did not even own a resident fitting the First Amendment complaint description. The only home he owned located within the territorial bounds of New York City was a townhouse on Park Avenue in Manhattan. But this townhouse was not a large white residence, was not gated, and did not have a U-shaped driveway. The remainder of the homes Mr. Combs owned at or around this time were not located in New York City. For example, Mr. Combs owned a home in East Hampton, more than a 2-hour drive and 100 miles from Radio City. This home was not gated, did not have a U-shaped driveway, and did not have a gas station within 5 miles. Mr. Combs also owned a home in Saddle River, New Jersey, but he sold it in 1998, so he wasn't the owner of that house anymore, 2 years before the alleged assault. And the Saddle River home was not gated, did not have a U-shaped driveway, and did not have a gas station within 2 miles. Finally, Mr. Combs owned a home in Alpine, New York, Jersey, but he did not purchase it until 2000, 4 years after the alleged assault. The Alpine home was not white and did not have a gas station within 2 miles. So it sounds like that one may have had a U-shaped driveway and potentially a gated driveway. It may not have been white. Maybe it was gray. Maybe it was another color. Where I think they're going to fall short on this one is because, like I said earlier, is that there is allegations that maybe she got the year wrong and maybe it was the 2003 VMAs. And so if she does discovery and figure that out and who performed at what VMAs and whatever it is, then she could potentially say, oh, well, now I am within the statute. And, oh, well, he did have a house like this. I know they're saying this house was not bought into 2004, but again, that's going to take more discovery. Jay-Z is just putting this into the documents and saying this to be true. You searched every single record that Diddy had. Is it also by his companies? Did you search what properties may have been owned by his companies at the time, or did you only search what properties were owned by Diddy himself personally at the time? All of those things are going to have to come out in discovery. He can't just say, oh, no, I know Diddy. He only had one house in New York at that time in 2000. How do you know what houses he had in 2000, right? You got to search. You got to do the research. Are you searching under any name that he could have had? Could he have had a house under his mom's name? All of those things can come into play. So I see how he's just kind of put in, no, he didn't own that, right? And at this time, he didn't own it. But do you really know? No, you're going to have to go through discovery to find out if he had these homes, right? So again, just presenting facts that are I guess you could say public record because you can look at who owned homes, but are you really giving us every single scenario in which Diddy could have owned this home? That would be the question. That would be a question I would be asking as a judge. But I'm not a judge. So I guess what I have to ask it doesn't matter. It doesn't matter. Okay. Publicly available information also shows that it is implausible that plaintiff would have been able to reach a neighborhood, both within New York City and the Southern District of New York, housing a resident that matches the First Amendment complaint descriptions. Again, she said that she probably estimated it as far as time goes. And the court gives a wide latitude for victims, especially child victims, when they are estimating things like time, the month, the day, even the day of when this happened. They give them a long latitude of, okay, it took 20 minutes. Oh, well, maybe it actually took 45 minutes. So he's harping on these statements that he is already pointing out to the court that she said she may have made some mistakes, right? She's saying that she may have made some mistakes, but you're trying to hold her to it. And in a complaint, you are supposed to be as accurate as possible and give the most facts as possible. But when we're talking about a victim of SA and a minor, she's going to have a long latitude of the estimations that she can make. So I get where he's going with it. I don't think it's a basis to get it dismissed. A Google Maps search reveals that on a Thursday in early September with moderate traffic between 11 p.m. and midnight, it would take approximately 7 to 16 minutes just to get onto the West Side Highway from Radio City. Again, we're looking at the time estimates now, not in 2000. According to the plaintiff's own allegations in the First Amendment complaint, this would leave a mere 13 minutes at most to reach the supposed large white gated residence with a U-shaped driveway. In that amount of time, however, it is impossible only to reach High Bridge, Mount Eden, or Morris Heights in the Bronx. A Google Map aerial view search shows no houses matching plaintiff's description in any of these neighborhoods. Rerouting along the FDR drive is no more availing for plaintiff. Under similar conditions, a drive from Radio City just to the FDR drive would take 7 to 14 minutes, leaving 13 minutes at best to reach the residence where plaintiff alleges the assault occurred. But again, the options are limited, and that suffices only to reach Mount Haven and the South Bronx, neither of which contain houses matching the First Amendment complaint description. And I think again where Jay-Z is going to fail on this argument is, can people change their driveway over 20 years? Literally, where my house is right now, it did not exist 5 years ago. So are you telling me that people cannot change their homes over that time frame? Now, do I think that this plaintiff knows all the facts and is going to be able to testify to it and prove her case? Probably not. But the court is going to take the plaintiff's statements as true. They're going to take it as true. And you can argue all the technicalities all you want. But like I said, her estimation is going to be given broad discretion, broad leniency to determine whether, okay, yeah, maybe being an hour for 20 minutes or 40 minutes, that's not too far off. Now, if it was a 6-hour drive, like she's saying from her house to Radio City, then okay, that one might be okay. You really exaggerated on that one. But 20 to 45 minutes, maybe even to an hour, that might not be a huge discrepancy to the court. Okay. So then they go through the procedural history and the fact that she filed the First Amendment, or she filed the complaint. She added Jay-Z to the First Amendment complaint, and now we are here, and he's asking for it to be dismissed. I did want to read on this paragraph, and then we'll jump into the legal standard in which they're asking the court to review this motion to dismiss. Failure to state a claim is where we're at. Jay-Z points out, when the GMVPA was passed, it imposed a 7-year statute of limitations, which was extended to 9 years for individuals who could not commence a suit at the time of the claimed accrual due to infancy, injury, or disability. So they gave an extra 7 years, or sorry, they gave an extra 2 years to people that couldn't file the claim because there probably was a minor, right? So in her situation, the latest that she could have filed the claim was 2009. That would have been the latest she can file the claim under the regular GMVA or the GMVPA statute. There was a reopening. Let's go back into it. Before I mess it up, right? So 2009 would have been the latest that she could have filed her claim based under the regular statute of limitation. On January 9, 2022, the city council amended this provision to revive claims previously time barred so long as they were commenced not earlier than 6 months after and not later than 2 years and 6 months after September 1st, 2022. So what is that? March 2022 and they're going to tell us, huh? As such, the revival window opened on March 1st, 2023 and closed on March 1st, 2025. So you could still bring these actions. And that's why she's suing under the gender motivated Violence Protection Act, because the window for bringing time barred assaults incidences, I'm sorry, I can't think of words right now, incidences is still open. This is the only one that she can still sue under. Okay, like I talked about the CSVA and the ASVA, those ones are no longer open. One of them closed in 2021 and the other one closed in 2023. The reason why Jay-Z is arguing she is not justified in filing under this particular gender motivated Victims Protection Act. The reason why she cannot sue under it is because the law did not exist at the time that she is claiming the incident actually occurred. That is his position. I hope that makes sense. I feel like I'm saying a lot of words and I don't know if it's making sense right now. Okay. Anyways, this provision, the GMVPA created a new cause of action. The GMVA revival amendment contains no provision purporting to extend its reach to conduct that predated the 2022 enactment or the 2000 GMVPA enactment. So that December 2000 date has not been overcome. Now I'm telling y'all, she probably gonna come out and say this happened in 2003. I think she is gonna come out and say it was, I said 2000, but I actually meant 2003. But I don't know if that would justify her just amending this complaint. I would love to see what Busby's answer is going to be. And so this is a request to dismiss based on a failure to state a claim. And he's basically saying she didn't state a claim because there is no retroactivity to this. Although there is a revival period, it cannot go beyond when the law was enacted. So she shouldn't be able to sue under that. They're saying that she missed her opportunity to sue under the Child Survival Act because she was a child at the time. And they are also saying that this does not happen in New York, which is also required by the statute that they are suing under. There's a little bit of discrepancy that I'm a little confused about whether it has to actually occur in New York City or if it can be New York State. My understanding that it would be New York State in general, but I guess I can look it up while we are here. Gender motivated. I keep saying gender motivated victim, but it's gender motivated violence. I'm just scrolling that name all the way up. Gender Motivated Violence Protection Act, New York. Let's see what it says. Let's read the law. Let's not rely on the citations of okay. It is a New York City law. Okay, I was wrong. Let's see. This is just an article. So let me try to find the actual. Here we go. I want the actual law. I don't want your articles, people. Here we go. No, this is just telling me the history. Sorry, y'all. I'm trying to find it. Or we might have to just go with the article. Or I guess I can find the citation in the actual document that I'm looking at, but I'm just being lazy. I'm just being lazy. So let me bring me back and try to find that. Because I want to know what the law is. Tell me what the actual law is. Citations are needed. Citations to statute. That's cases. Cases, statute. Okay. Okay. I don't know which one this is. They're all just numbers. Okay. Maybe I have to find it at a different time. I don't want people's articles on it. I just want the actual law. They just gave me the full chapter 9. Okay, so let me see if I see chapter 9. Chapter 9. I do not see chapter 9. Where are you? Let me try this other one because that one looked promising. Sorry, y'all. I'm getting distracted and now I feel like I have to find it. So here we are looking for it. Okay, y'all. I can't find it. I can't find it. And I don't want to make y'all watch me try to find it. But now I feel stressed and I need to find the actual law. Okay. Let me get back on track because I clearly can't find it and I don't want to dive too far off. Maybe once we get through what I want to get through, I'll go back and look for it. But right now, I'm gonna jump back into wherever I was because now I don't even know where I was. Oh, I was in the standard, the legal standard for review. Failure to state a claim, they have to state facts. Enough facts to state a claim of a relief that is plausible on its face. They basically have to take what the plaintiff is saying as true. Although, like I've been saying, although Jay-Z keeps trying to point out where she's had falsities, right? The court has to look at what's in front of them. They can't talk about, they cannot consider the interview until that is entered into evidence, right? Motion to dismiss is mainly going to be based on what is in the complaint. Let's get it dismissed. She has not stated under oath that what she said in that interview is accurate. This complaint is what the court has to look at. They have to impeach her or basically contradict her on the stand by saying, but didn't you say this? But didn't you say this? But didn't you say this? Just because he puts it in the motion to dismiss does not mean that the court has to take what he's saying in the motion to dismiss. So taking her facts as true, she may still have a claim unless the court rules on that, the date of the incident, right? You can't go retroactivity. I do think that Jay-Z has a good argument on that. But that's the legal standard, is they have to state enough to state a plausible claim that can uphold. And Jay-Z's strongest argument is that it happened in 2000. And the look back period for the Child Survivors Act is also already closed, right? The only one that is still open is the Gender Motivated Violence Protection Act. Okay, I got that one right this time. Okay. So Jay-Z goes on to argue that this one should be dismissed because the GMVPA does not apply to retroactivity. I'm not going to lie to y'all. I'm not going to read all this because it's a bunch of citing cases and we don't have time for that. So let me try to explain it with my words the best I can. I feel like I have been explaining it, but I feel like it hasn't been the best explanation as possible, right? So Gender Motivated Violence Protection Act has a revival period that is still open until March 1st for any claims that would have been barred by the original statute of limitations. So 9 years if you were a child would be the statute of limitations, and 7 years if you were an adult at the time would have been the statute of limitations for the Gender Motivated Violence Protection Act only. That revival period is still open, but the law was only enacted in 2000, December 2000. She is alleging that the incident happened in September 2000, and Jay-Z is basically arguing that, well, she can't say that she's suing under a law that didn't even exist at the time that she's alleging the incident happened. It basically puts him in a position where he can't defend against these claims. And he points out to the fact where there's no witnesses and there's no evidence and whatever, but the statute, the revival period didn't care about any of that. It revived any time barred incidences, right? They didn't care about that. What his best argument is that, okay, well, that law didn't exist at that time. So how could I have known, even if I am guilty, how could I have known that I was violating any law? Because y'all expect us to know all laws, even though people do not know all laws. Some people don't even know what side to ride their bike on the side of the street, okay? If they can ride it on the sidewalk. Most people don't even know that. So he goes through the retroactivity of that, which is fine, right? I agree with him. If the statute was not existing, there does not seem to be any legislature that says that they intended for it to apply retroactively, and it is common practice for, if the statute does not say it applies retroactively, that it does not apply retroactively, then the court will not hold it retroactively. And this particular court has actually seen a bunch of cases where they were trying to have the case go forward, like maybe something that happened in 1999, and the court says, no, the legislature did not mean for this to apply retroactively, so no, we cannot use it. So fine. He gets through the gender motivated. Sorry, y'all. These headphones make weird noises sometimes. The Gender Motivated Violence Protection Act. Then he moves on to the Child Survivors Act and the Adult Survivors Act, right? I think it was like Child Victims Survivors Act and then the Adult Survivors Act. And so those ones also had opening windows. I'm sorry, not opening, revival windows. They had revival windows, Brie. And so the child one closed in 2021, and then the Adult Survivors Act one closed in 2023. She did not file the case until 2024. And now while the Child Survivors Act and the Adult Survivors Act actually went beyond that 2000 date, so had she filed it in 2021 or 2023, she would have been just fine. But since she didn't file it during that, she basically lost her opportunity. And again, there has been other cases that have tried to file after those closed windows, and they're trying to sue under the Gender Motivated Violence Protection Act because the revival window is still open, but the Gender Motivated Violence, the GMVPA, okay, that one doesn't go as far back as the Child Survivors Act and the Adult Survivors Act. Those ones go years back. There is no retroactivity argument to it. The argument regarding those ones is that the revival period has closed. I hope that one makes sense. Okay. And then the next thing that he goes into is that this did not happen in New York. And then he goes through, well, he didn't own a house at that time and he didn't own it. It took him this long to get to a gas station. And there was no house like that if we do a surveillance overlook, right? So, sorry, y'all. My Ring camera is going off and it's giving me anxiety. So he tries to argue that there's no way that this incident could have happened in New York City. And I do want to look into that a little bit more of if it's just New York State or if it is also New York City. Okay. He tries to harp on the fact that her facts are incorrect, which again is going to have to be proven in more legal documents and in more legal documents and in hearings. I don't think that's a good argument. I mean, it's getting his point out. And so it's going to be so wrapped into the judge's brain because they have to keep reading it, and trying to ignore it it's going to become hard. So that's pretty much it. We don't have an answer of whether Jay-Z at least is dismissed or the entire complaint is dismissed. based on this, because he literally just filed this motion to dismiss, and Busby has some time. I don't remember the exact date, somewhere I think towards the end of February, to go ahead and respond to this, and we'll see what their position is. And then I believe they also have a hearing set, but I don't remember those dates off the top of my head, and I have not gone and pulled those documents. I have it somewhere, but I just haven't pulled that document today to remind y'all of what those dates are. But what we do know that there is a dismissal on is Busby has voluntarily dismissed allegations against two of the defendants in the case. And I'm sure y'all are aware that it is not Diddy and it is not Sean Carter, it's not Jay-Z. They are still listed as defendants in the case. But who they did dismiss with prejudice, I might say, meaning that they cannot bring these allegations back against these two defendants, is the defendant Bad Boy Records LLC, who they were probably trying to pierce the corporate veil on Diddy, kind of like the RICO conspiracy charges Diddy is facing in the criminal court. And they also removed, oh, never mind. It's only one defendant, only the Bad Boy Records LLC. I thought it was multiple people. Was there another one that I forgot to grab or something? Anyways, Bad Boys Records is dismissed from the case. Jay-Z is still on the case. Diddy is still on the case. All the other people and companies that they listed is on the case. But Bad Boys Record, they have been dismissed. So there's an update there. And like I said earlier in the stream, the sanctions that Jay-Z filed against Busby have been removed, but that's without prejudice. So they can file that again. Now that there's an order out that Busby has to get the court the information that he is licensed to practice in the court as soon as possible, i.e. before he files his response to this motion to dismiss. If he doesn't do it at that time, then we will probably see Jay-Z filing another motion for sanctions against Busby directly. So that is all that we have on documents for today. So I'm going to have Bossy B go ahead and bring us in. And we're going to jump into the chat. So y'all let me know y'all thoughts. I know I kind of struggled through that one. I'm trying to get used to streaming again. Kimmy went ahead and started the chats that are relevant to what we're talking about. Just want to say hello to everyone that has jumped in. I see Tanya D, also known as Destined to be a member and moderator of the channel, commenting. We got Kimmy Locker, who is a member, moderator of the channel, consultant, paralegal of the channel, also commenting. Welcome in. Nice to have you back. And y'all are the only two commenting, so I don't know who else is here live. Yeah, I don't know who else is here live. If y'all watching on the replay, make sure, like I said, go ahead and drop comments. Let me know your thoughts on the case. Let's see what the people have to say. Kimmy Locker saying, if the case is dismissed due to the statute of limitation or location, then that's just bad lawyering on Busby's part, in my opinion. And it sounds like there was a bunch of recent cases where they did dismiss these same kind of allegations, where it could have been either CSA or ASA. I think it's CVA. I keep saying it's CSA because it's just easier. But CVA and ASA, and they're trying to sue under the gender motivated, but they filed it too late. They've had a lot of cases like that go forward where they're like, no, we're not applying it retroactively. Okay. I cannot talk right now, okay? Tanya D is agreeing with the statement by Kimmy. But my thing is, like, would we really be surprised? Dealing with Busby, will we really be surprised if it gets dismissed on that? And this is going to serve as further precedence. Not only do the cases that have already ruled that you cannot try to revive a claim that's beyond 2000 retroactively. Why can I not say that today? I say that all the time in court, and I can retroactively. What am I trying to say here? Retroactively. It's going to apply to some of the other cases that Busby is filing, such as, what was it, the 16-year-old boy that happened in 1998. I think there was another one in 1999. There's going to be a bunch of other cases that are going to be limited if they do set this precedence in this court, which is the court that Busby has been filing in, right? We got Queen Brielle giving us a wave. Hello and welcome in. Nice to have you in. So I think that they have a lot They have a lot to overcome. I do think that Jay-Z is correct in the retroactivity part. Retroactivity. I think he's correct in that. I want to look more into the law and say, it doesn't have to be in New York City. That sounds weird, but they're saying it's a New York City law. Specific to New York City. Gender motivated. We're going to try this again since we got time. We got time. We're still under the hour mark. So let me try this again. Gender motivated Violence Protection Act, New York. It's a New York City law that allows sexual abuse survivors to file civil claims within a specific time period. It aims to protect both men and women from gender-based violence, recognizing acts of SA and abuse as forms of violence inherently motivated by the gender of the victim. The law makes it unlawful to commit an act of violence because of an individual's gender, and those who do so may face criminal prosecution and civil recovery. The whatever, they put a lot more letters in there, entitle individuals to recover damages, including economic, compensatory, and punitive damages, as well as attorney's fees and adjunctive relief. It applies to all residents and workers of New York City. But does it have to happen in New York City is what I would like to know. Revival window is still open. What is the freaking code number so I can see it? And so they actually modeled this look back window after the CVA one. Yeah. I still can't find it, y'all. I don't want to make y'all struggle with me through this. Let's go to the bar's website. It keeps saying it's a New York City law. So, I mean, it would make sense to me that it will have to happen in New York City, but there were some cases that Jay-Z was citing that said it could either be New York State or New York City, but they basically alleged she didn't even say where it ever took place. It's just that it was 20 minutes outside of Radio City. Again, that estimation could be a little bit off. I wouldn't fault her too much for the estimation of the 20 minutes. But he is right. She did fail to state that this happened in New York City. She basically wants the court to assume that it happened in New York State, but she doesn't really indicate whether it happened in New York City. So let's see. Kimmy Locker says, I wouldn't be surprised, but I'd be annoyed if it happens. He's either distracting from true victims with reckless lawsuits, or he's letting true victims down with reckless lawyering. Yeah, that is a good point to make. I think some of his victims or some of his clients are fake, and I think some of them are potentially real. But he's trying to draw attention to his law firm. I don't think his representation so far would make people want to hire him. I definitely wouldn't hire him with what's going on so far. But yeah, I can agree with that statement. Either distracting from true victims with reckless lawsuits or letting true victims down with reckless lawyering. That is a good way to put it, Kimmy. I agree with that. Queen Brielle says, yes, it's specific to New York City. Yep, you are right. You are right. I know there's one for California as well, but I don't know if that one's specific to a city. But the particular one that we're talking about in these lawsuits is New York City. I don't know why that case, he cited a case somewhere in there that said they need to clarify that whether it's New York City or New York State. It could have just been a typo. I don't know. But either way it goes, we figured it out. I still didn't find the actual code number so I can actually read the full code, but maybe I'll try to look for that at a different time. But anyways, y'all, that was all that I had for today. So thank you for joining me in the live stream. If y'all haven't already, please do hit the like button. It does help us out. We're at 22 likes, so shout out to the Brihive for hitting the like button on their way in and on their way out. Definitely appreciate it. I'm going to try to stream on Thursday, and I might be able to squeeze in a little Reddit kind of stream, just kind of looking at some insane am I the a-hole stories revolving around like divorce laws, suing your neighbor maybe. I don't know exactly which ones I would cover, but I am thinking about doing something like that tomorrow because I won't have anything else to do tomorrow night. So I should probably stream and hang out with y'all online. And then on Thursday, we are going to be covering the updates in Diddy's criminal lawsuit. Have y'all watched the documentary? I haven't watched it. My husband was watching it and I kind of saw a little bit of the documentary against Diddy, but I haven't really watched it all the way. And I don't know if I want to watch it since I'm covering the case. I feel like I know a lot of what's going on. And it's some of the people that are currently suing him, which is insane to me. Like, why would you be doing a documentary when you have a lawsuit? Like, they can use those statements against you, okay? Queen Brielle said, have a great night to everyone. You as well. Destined to be saying good night. Then Kitty Locker is saying, is that the 50 Cent documentary? I believe so. I believe so. Lola Waterton saying good night. Didn't see you in the chat earlier, but welcome in. And then Destined to Be says, I need to watch it. I don't know if I want to watch it until after we finish the cases. But I do know from what the little bit that I did see, it involved some of the people, not Busby's clients, okay? Because you know those ones are all anonymous. Not Busby clients, but some of the other cases that we cover. Like I specifically remember seeing Thalia Graves on there. I wasn't paying attention to anyone else to try to remember their names or to see their names, really. I just kind of heard it in walking by. So that is all I have for today. Again, I will see y'all on the next live stream, which may be Wednesday or which may be Thursday, but I will see y'all later on this week. I hope everyone has a good night, and I will see y'all on the next live stream. Bye.